Is there a conspiracy afoot? Did Blake Lively create a fake subpoena? We got employment lawyer Ron Zambrano here to break it all down. Welcome to Popcorn Planet. I am Andy Signore. So glad Kim's in the background. We're going to get her in a second, but Ron is back and he's here live with us. Welcome back, Ron. How are you doing?
I'm doing great. Thanks for having me back. I'm especially interested in this topic because you and I spoke about it when we first met.
So Ron was gracious enough to be in the documentary, which we just announced, everybody, if you're tuning in. It's called It Ends with Justice, Justin versus Blake, a documentary. We're very happy about it. You guys can actually invest in it now still. Check out the investor pack on our store. So many of you guys are already signing up. But I can tell you, Ron, I said it to you then, like, I knew you were going to be good, but I wasn't prepared because I was preparing so many things. And Ron was just blowing my mind throughout the whole interview. I'm like, oh my God, that's a really good point. Because you specialize in this. You are an employment attorney out in Hollywood. And again, you represents the dancers against Lizzo. You just won was it 400 million against Soldier Boy? Like, this is your bread and butter. Is it safe to say that?
Yeah, this is my wheelhouse, and I'm lucky enough to make a living representing people that are the victims of those who abuse their power, as I like to frame it. And yeah, this is my wheelhouse. I love this type of work and employment rights and here in LA.
So if someone is wronged by a celebrity, they should call you.
Yes. Yes.
There it is.
Well, right. Because it's a different fight than a normal corporation. It is, and I've learned that through some of my own trials and tribulations. It is a different fight when you take on somebody with a lot of resources and power and people backing them.
Because I imagine these people can't afford it, so you have to vet it to make sure that it's worth your time to go through it, right? So if you're taking the case, there's something sketchy going on.
Unlike what BuzzFeed's done, but that's another conversation.
Oh, we will definitely follow up on that. All right. So but let's get into this topic because we have it here. This new twist could turn Blake Lively's legal battle on its head as Justin Baldoni's team reveals a major flaw. So for those of you unaware, you should know this if you're following the channel. Stephanie Jones, who I'll be honest, seems not like the nicest person in the world, somehow got this phone from Justin's publicists. Took this phone, the text from that phone were then used in the New York Times piece and then in Blake Lively's lawsuit. And the question's always been like, well, how did they get this phone? Why did Jernnifer Abel just hand over this phone so easily? What happened? New York Times and Blake and all of them say, well, they were subpoenaed. And we've all been waiting to wonder, well, what did this subpoena? Where did it come from? And so there's no doubt that Stephanie willingly maliciously spread private and confidential communications concerning her former clients in an effort to humiliate them and destroy the fledgling business and reputation of her former employee. Friedman said in a statement how she only sent the messages out of spite. She did so purely out of spite to prior any phantom subpoena that we have yet to see. Now, Blake's team has fought back. While Friedman's saying the subpoena requires a case number from a legal case to be referenced and no case was ever filed, Jones or anyone prior to giving Blake those text messages. But Jones's lawyer now is fighting back. More distractions, yet no defense for what the whole world saw in those text messages. If Mr. Baldoni or his attorneys believe the subpoena legally requiring Miss Jones to turn over the damning evidence demonstrating his client orchestrated a smear campaign against Miss Lively is fake, he should sign an affidavit saying so, and we look forward to the discovery process. So, Ron, I come back to you. Both sides fighting this. I do have to admit, why doesn't he do that? Is this fake? What's happening with this mystery subpoena? What are your thoughts?
So, again, this is a good effort to switch the narrative as to who's supposed to be responsible for what. At the end of the day, and later on in this very article that you shared with me earlier, there is supposedly a subpoena that's signed by an attorney over at Manat Phelps. And that attorney, whoever signed that, and maybe even the firm, could be subject to very, very serious sanctions from the courts, and also maybe from whatever state bar they're assigned to if they misrepresented that an active case existed for there to be the power of the subpoena. That is not something that you should ever do. That is, law school year one. And they can try to flail and go, well, they're accusing us of this, that, and the other thing. But at the end of the day, this document is going to be revealed to the other side, and the other side is going to go ham if it was in fact supposedly representing that a New York case already existed when it didn't. That is going to be, there's so many implications on that on so many different levels. to the person that's misrepresenting it, the attorney themselves, to the misrepresentation, to the to this particular person, because they don't know. If you're not a lawyer, you don't know. I mean, I would know, like, wait a minute, like I would go check the case number. I'd go. But if you don't know, you're acting like this person's an attorney. They're not, they wouldn't lie to me, but sometimes they do, unfortunately.
So I guess that's so interestingly enough, like, because I've spoken to other experts, I've seen other people talk on this. That's why I wanted to come to you. Like, I've been told, well, yeah, you can, have a friendly subpoena. If you have somebody who wants to give you information, but they can't, you can request, well, yeah, subpoena me and I'll give it to you. And then they go file some phantom case along with a phantom subpoena, and then it's divvied up. Is there any sort of legal shenanigans that they're going to get away with that they could pull out of their butts on this? Or you're saying, no, this is definitely problematic?
No. A subpoena only exists because there's an actual threat of contempt by not following the order, and you cannot have that threat of contempt if there's no actual jurisdiction by a court. So we're going to follow the thread through, right? You get a subpoena because it is connected to an existing case, and the existing case has an existing presiding judge with an existing lawsuit and an existing two parties, right? If that doesn't exist, there is no subpoena. There's no such, it's like being kind of pregnant. You either are pregnant or you're not pregnant. There either is a case or there's not a case. So if someone has drawn up and just filled out the form without actually there being any case in New York at that time, that is a fraud by the attorneys. And then it is also a fraud on the courts because you're misrepresented. Like there is so many consequences from this. This is not like there's no such thing as a friendly subpoena. It's either you either are subject to contempt by not following it, or court orders by not following it, or it's basically, a text message asking for stuff. Like there's no in between.
So Daily, it's weird because Deadline and Daily Mail both says they have seen this. Friedman saying he hasn't. Dated on October 1st, it says it was filed in Manhattan Supreme Court, but it has no court stamp on it. It is signed by an attorney working for the New York law firm of Mennett, Phillips, and Phillips, who represents Lively and her husband, Ryan. It orders Jones to hand over all documents and communications concerning Lively and Reynolds and their companies. Friedman claims there was anyway, that's before we go there, I want to react to this. So this is what Daily Mail is reporting. So your reaction to this is what? Is that typical to have something like this without a court stamp? Is that a red flag to you?
Yes, if there is no case number, it's either the attorney screwed up, or it doesn't exist. And if it doesn't exist, it is a very, very, very serious breach of a lot of rules for the attorneys, for the attorneys, and for the firm. It is something that you should not ever play around with. And if this is true, again, we're relying that we're going to take this at face value. And I believe this is connected to how, and I told you this at the documentary, I think the New York Times was duped. I think because they would not have messed around if they're like, wait a minute, if there's no lawsuit, that means we're not supposed to know, and we are going to stay above this fray until there is a lawsuit. I really believe this is the source. What we're seeing now, this fake subpoena, quote unquote friendly, which cannot exist, is how I believe, this is my theory and hypothesis, and you can call it whatever you want. That is what ultimately gave the New York Times that there was some semblance of playing above the fray, and there was actual
validity,
lawsuits some validity that, like, oh, we can talk about something that is publicly accessible when it wasn't, because there was no actual case that you can issue a subpoena from in order to, unfortunately, bully somebody who doesn't know better to give something up that they didn't have to.
I can see my audience frothing at the bit and excitement of just what you're putting out there, because this is a pretty big deal. And I guess, can the New York Times then say, oh my gosh, well, we were sold a bill of goods, but wouldn't that also be on them to like verify it's for real and not just be like, trust me, bro? Making the assumption that the New York Times relied on this document to satisfy their requirement, because I'm sure they have a requirement that before we move forward, this stuff has to be, you're telling me this is going to be publicly accessible at the time we publish. And I'm sure someone said yes, and that whether it was intentional or not, that did not end up being true. I'm sure whatever document that the subpoena is from is a source, if not what was used to be like, oh yeah, look, we're subpoenaing people, it's okay. And I think that's what I believe ultimately misled the New York Times, because
I 100% believe that the New York Times at no point would have published that story had someone said, "Listen, this complaint that we've given you, it's actually something in a private agency in California and is not publicly accessible." Had they been transparent and the New York Times knew that, the editors, they would have been like, "Well, we can't report on it because there's too many." It's they just stay above the fray. New York Times does not mess around with a reputation, and now they have gotten hit. And I'm pretty sure somebody omitted the truth as to whether this was an actually public filing or not.
Well, the metadata is also proving that, right? I mean, it was clear they had it. I imagine you work with outlets as a lawyer, right? Lawyers work with these outlets to preemptively get ahead of stories. No, it's not crazy of us to assume Blake and the New York Times were working in tandem to get it out, correct?
No, not at all. I mean, this is when you're dealing with cases that you anticipate national interest and national media interest, you typically have contacts through other people to publish these things and you work with them. The problem is I know that these high level media outlets, the New York Times, the Wall Street Journal, I've dealt with those people and I've had conversations with their lawyers to me going, "Are you sure this is going to be filed on this day? I want to see a case number." I've had those conversations. So that's why I come from that space going, someone from Lively's team had a conversation from somebody at the editor's level above at the New York Times before they did this. And either there was a miscommunication or somebody was omitting or stretching the truth as to whether what was happening in California with the Civil Rights Department was actually a public filing that can be accessible to everyone.
Insane. Bruce, Alina, I saw your question. I know you can't afford a super chat. We read all of them, and it's a good question. If there was fraud found here, this is what it is. Could they dismiss the text messages?
No. No. So evidence that is, well, it's a timing issue. So the evidence exists, right? There anywhere, right? There's text messages on a phone, and at the end of the day, the judge in any case wants to get to truth and justice. So they want to see everything come in so that a jury can make a decision on everything. The idea of keeping something out is such an extreme thing. It depends why. It depends on the motive for that type of ruling, and I think it would not be the it would I think it would punish both sides because remember the threads weren't full. The full threads help Baldoni, right? So I don't think it'll be kept out. What I really think the consequences are, again, assuming that this was a intentional misrepresentation by attorneys at some firm, there will be consequences for making those types of representations to those specific attorneys, if not to the firm itself, because that is a big no-no.
I want to bring Kim into the fold. Kim, you had a question for
Hi.
Ron.
Yeah, my main question was simply because I have seen some discussion online regarding the subpoenas and the idea that if there was a subpoena issued, that certain parties would have need to have been notified. If there was a subpoena issued to do with Jennifer
That's a
Abel's
good point.
phone, would she not have been notified?
So yeah, that's a good point. In the normal in the normal course of things,
Yeah, the normal. We know we're not there, but yeah.
right. When one party issues a subpoena for anybody, either the other side or a third party, there's supposed to be notice requirement to the other side, like, hey, defendant or plaintiff, whoever, hey, opponent, we're going to seek documents from this third party. I have to give you notice because those are the rules. So not only would have the person that possesses the phone have to have notice, but also Baldoni's team would have had notice because it was in connection to that dispute, supposedly. And I can assume because it hasn't been brought up that notice to the other side was never brought up. So that's another thing that makes this not the lack of notice to people that should normally get notice lends credence to the theory that this was done intentionally in a not so above board way.
Okay.
Someone else
Thank
just
you.
brought up. Yeah, good question, Kim. So, like, does it matter when it was dated? Can they have done this after the fact? Because I've heard that theory too of just like, well, they didn't get it before, but New York Times, they're all working together, but they got it later. Can that? I guess the date is after they got the text. Does the timeline of it matter? Is there a version of this where they could have gone and filed something that we don't see?
No, the focus is for purposes of this particular side of the story is this. At the time that the phone was handed over, what is that person reacting to? And at that time, if they're reacting to a subpoena that isn't a subpoena, that is being misrepresented as having the power of a court behind it, at that point, that is the violation of the rules at that point. That later on, they were like, well, we would have gotten them later anyway. We would have gotten a subpoena later anyway, which is true, right? Right now, they could subpoena them. But the thing is that they got them under a misrepresentation. That is the definition of fraud, right? I've committed a fraud on you for you to do something that otherwise, had I been honest, you probably would not have done because you would have known the truth. This is if this was a if this really is this document of a New York Times a state of New York court form without a New York case existing, because it didn't, it is potentially a very serious form of fraudulent conduct in order to induce someone to do something that they wouldn't otherwise do.
So who's in trouble then? Who can sue who, and who's going to get the ramifications of that? I mean, is it Jernnifer able to sue Stephanie Jones for giving that away? Is it New York Times for being misled? Is it Baldoni for being defamed? Who can use this to their advantage?
It's so Jernnifer can make a potentially, again, assuming this is what happened, she can go after the firm, Manette Phelps. Baldoni, if this is true, if Manette Phelps or one of their attorneys misrepresented, and these are big boys, right? These are not small timers. If they actually misrepresented the existence of a lawsuit to pretend that there's subpoena power, if there's a chance, and again, Friedman seems to be a no joke kind of guy, can move to disqualify Manette Phelps from being in the case any longer for engaging in that conduct in the first place. Now, I don't know the rules as far as what the standard is in New York or New York District Court, but a judge might be pissed off enough going like, you guys have acted, I've seen this, I'm assuming all this is true, what we're reading from the Daily Mail is true, that you, Manette Phelps, have misrepresented back in October that there was an active court case in order to basically dupe someone into believing there was subpoena power. If I was representing Baldoni, I would absolutely take that swing and file that motion. And there'd be a lot of anxiety at Manette Phelps over it, because the judge might go, you know what? Yeah, this is grounds to disqualify your firm from participating any longer, and we're gonna you have to find a new law firm. It's possible.
I love that he just sips the tea. Let's talk about the tea.
It just is. I know. I
I'm
love
sorry.
it.
I'm sorry. That's not I'm just a little sick. I'm sorry, but thank you.
No, that was slick.
Thank you for choosing to be with us then when you're not feeling well. We do appreciate that. Andy, I did have one other question, if it's okay if I ask. When it comes to this case, though, part of what makes this a bit more complicated was the original piece of this was the CRD complaint. Are there any differences in rules of getting information because of a CRD complaint that could influence this?
Yeah, so Andy will remember, I brought this up when we were sitting down in Calabasas, that there is no subpoena power from the parties during a pending investigation with the Civil Rights Department in California, unlike it when you're in state court. Now, under certain circumstances, if the agency itself wishes to take on the case, right? They're like, oh, wow, yes, you're right, Ms. Lively, this is terrible. We will now use the California's resources and we will represent your interests in this harassment complaint. The department in that proceeding has subpoena power itself, but the parties individually do not until they get into some type of state court or federal court.
Okay. So if there was to be a subpoena that would be following the law in this case, it would have had to have been California itself?
Yes, because it was connected to
So it shouldn't have been Ryan.
No, it should not have been Ryan. Unless there's some secret
or
other complaint we don't know about.
Yeah, or whether it's, I'm so not saying Ryan specifically, but just saying because it's the law firm that represents both Lively and Ryan, it could be assumed, and I can't say that for sure, but what would be the chances that California would be going to this New York law firm to get the subpoena?
Zero.
Oh, yeah.
And it wouldn't, so that's why I'm being so kind of absolute about this, because unless there happens to be a New York pending lawsuit that just happened to have been omitted on this document, and no one has reported up until now, which is very unlikely. Everything at that time was happening in California. And so if a subpoena existed that had any type of truth or teeth to it, it had to have come from California, one, but not just from a California court, but from the agency itself through the Civil Rights Department process. So it wouldn't look like a normal court document. It'd look like another state-specific form. So that's why I'm being like, this stuff from New York probably is not true. I'm assuming it's not true because no one has talked about it, like, oh yeah. There was a New York, while we were doing the Civil Rights Department back in 2024, there was also a pending, New York case that we dropped, but we just existed just for, like it doesn't, I really do think this phantom thing. I don't know. Maybe they'll blame AI. I don't know.
Man, that was a fantastic conversation with Ron. You can watch the whole show on our Patreon where you can catch all the replays. He hung around for a bit more, answered more questions. And we talked about that awkward Another Simple Favor appearance. My gosh, what is going on here? Stay tuned to watch more. Hit the subscribe. Make sure you support It's Kim as well. We got a lot more coming your way. And don't forget to head over to Patreon right now and get your It Ends with Justice investor pack. It's now available. You can be part of our documentary. You'll get an investor credit along with the exclusive shirt and sticker. So check it out. Make sure to read the whole information so you get to get your name properly in the credits. But go support it. I'll pin it in the comments, etc. Look at our link tree. It's the first thing in our store. Go check it out over there. Make sure you subscribe if you haven't already. Hit that bell for all alerts. If you're watching live or on the replay, hit all. Smash that like when you get those notifications. Leave a comment. It helps the algorithm as well. Hit that like right now and stay tuned. We got a lot more coming your way. We're going to send you over to Lewis next over at Nerd Report. You guys are the damn best. We will see you soon. Thanks for everybody who's stepping up and supporting our